Thank you for joining us all today. I'm Pamela Forward, President and Founding Director of Whistleblowing Canada Research Society. A few words about us for those who are new to our webinars. We were founded in 2019. Whistleblowing Canada Research Society is a registered charity. And the organization's purpose is to advance education on whistleblowing by conducting research on the whistleblowing phenomena and culture in Canada, thus capturing existing knowledge, discovering new knowledge, and sharing the information through seminars, conferences, and training for the interested general public, as well as employees, whistleblowers, and leaders in Canadian public and private organizations. As a newly registered charity, Whistleblowing Canada relies on public support to expand its activities. So if you're so inclined, you can donate to the organization via our website. Your presence and your interest mean a lot to us. So today I have the privilege of hosting a presentation and discussion on why Canada's whistleblower protection legislation is tied for last place, an analysis of countries with best practices in their relationships with whistleblowers as enshrined in legislation. Today's talk is presented by Tom Devine and moderated by David Yazbeck, whom you just briefly met. And we're delighted that they have agreed to be with us to do this. Tom Devine, our presenter, is Legal Director for the Government Accountability Project, otherwise known as GAP, in Washington, D.C. And he's also an advisory board member with Whistleblowing Canada. Tom has worked at GAP since 1979, and since that time, he has formally or informally assisted over 7,000 whistleblowers in defending themselves against retaliation and in making real differences on behalf of the public. He has not lost a case since 2006 and has prevailed in advocacy at numerous U.S. courts of appeal, as well as the Supreme Court. Tom has been a leader in the campaigns to pass or defend 34 national or international whistleblower laws, including nearly all in the US federally. David Yazbeck, our moderator for today's discussion, is a lawyer at Raven Law and a member of Whistleblowing Canada's advisory board. He practices as an advocate for unions, for employees, and human rights complaints in the areas of labor relations, human rights, judicial review and appeals, and charter litigation, with an emphasis on the federal public sector. He has particular expertise in employee free speech, whistleblowing, and anti-reprisal complaints. So I'll turn the meeting. Welcome, Tom. Well,
Thank you.
While we were waiting for you, we did do the introductions. And David, maybe you could just briefly review with Tom what we're going to be doing.
Sure, thanks. Welcome, Tom. So glad you can be here. It's actually a real privilege for us to have you speak, particularly given your expertise and your experience, and given, I guess, arguably a more neutral, or at least a distant perspective from outside of Canada. So I understand that you have a presentation about the topic, and that will take approximately 30 minutes or so. We're running a little bit late, so if you can trim any time, that would be great, but you don't have to, because I think we all really want to hear what you have to say. And then once you have completed that, myself or Pam may have some questions, and of course we will invite our audience to participate in a conversation afterward about the issues you've raised. You might be asking questions yourself, So we're all anxious to hear from you. So I'll turn the floor over to you. Thanks, Tom.
Thank you very much. And again, I apologize for my delay. I think I'm probably as frustrated as you folks that I couldn't join you. I wanted to, and I very much appreciate the honor of being able to share our analysis with you today. I won't repeat the background and my own qualifications, but the context for this report to you folks is a report that my partner and I at the Government Accountability Project just completed with the International Bar Association, a study of whether the world's whistleblower laws are working. What is the quality of rights on paper, and what is the quality of rights in reality? And the reason that we did this is whistleblower laws are being enacted in an intensifying pace. It's almost like we're in the middle of a global legal revolution. In 1978, the United States was the first country in the world to pass a national whistleblower law. Second one wasn't until 1998 in Great Britain. Now we have 48 nations with national whistleblower laws. That's going up to 62 countries with these free speech rights, thanks to passage of the European Union Whistleblower Directive. And we're in the midst of a phenomenon. But like any other phenomenon, the quality of the results can be dramatically inconsistent. And some of these laws are outstanding. Some of them we think are almost like dangerous. And in fact, at Government Accountability Project, where I work at, we analogize these whistleblower laws like free speech shields. And where you blow the whistle, you're going into a battle, the battle of your life. And if you go in with a metal shield, it's dangerous, but you have a fighting chance to survive and to defend yourself and live. You go in with a cardboard shield, no matter how beautifully it's decorated and how nice it looks, you're going to die. So we put together 20 best practice criteria to distinguish between the metal and the cardboard shields, and assessed all the world's whistleblower laws by those criteria, and also in terms of their track records. Canada came out in terms of the best practice criteria, tied for last place with Lebanon. Actually, if we go into the specifics, Lebanon's tie for last was a little better than Canada's. I put you at the lowest common denominator globally for countries that have national whistleblower laws. And the track record reflects it. So let me start by giving you just some of the statistics on the track record. And then we can go into the reasons why we've had that poor performance. Now, the law went into effect in 2007, passed in 2005. There have been 8 cases that have made it to the courts, 3 from the same dispute. There have been 2 decisions on the merits in close to 14 years. The whistleblowers lost both of them. One decision took 2,398 days to be rendered. The other whistleblower waited 2,591 days to get an official defeat. There were 5 cases that were settled in mediation, so there's been some impact from the law. But 8 cases in court in 14 years, and no one winning a decision on the merits it's really it's the world's worst track record. And the explanation for the lack of access to court is very clear. The public commissioner in Canada, who has absolute veto power over your due process rights, as we'll discuss, from 2005 to 2020, 2007 to 2020, only allowed access to court in 6 out of 358 complaints. And that's really the essence of the weakness of Canada's whistleblower law. You don't have due process unless a commissioner with absolute authority who operates in total secrecy and has complete discretion decides to let you have them. And this happens very, very rarely. Well, that's the track record. Let's now go into some of the criteria that you have to have in a whistleblower law to be effective, and we'll compare their absence. And I want to say in overview, the insights and criticisms I'll be sharing with you today are not new or unique, and they're not just coming from our organization. Your parliament had an excellent series of hearings in 2017, and the Standing Committee for Government Operations put out a report that reflected the testimony of whistleblower experts from all over the world, from Australia, from Ireland, from the Whistleblowers International Network, myself, and what I'm sharing with you today is really kind of a synopsis of a global consensus about this particular law. Really the first principle that you have to have for an effective whistleblower law is that I call it no loopholes context for blowing the whistle. That your free speech rights aren't canceled out because of technicalities like formality, be written versus oral or oral, context, audience. You should be able to exercise your free speech rights wherever they're going to have an impact, the timing of your disclosures, and you should be able to go public with your information as a matter of freedom of speech, but at a minimum, if the internal or government channels are not credible or trustworthy or appropriate, you should be able to go public for them. You shouldn't have barriers against your disclosure, like your motives have to be tested. Were your motives sufficiently pure before that disclosure is covered by the Whistleblower Act? Were your motives in good faith? I mean, for goodness sakes, whistleblowing is about the information, not about a judgment of the witness. Some of the most significant witnesses in history were mafia hitmen, and we shielded their lives because we needed their testimony. We need the testimony of whistleblowers, whether we like them or not, or whether their motives are noble or self-serving. The only factor that's relevant for motives is credibility. Of course, that's relevant, but whether or not you're protected for disclosing the truth shouldn't depend on that. Well, Canada's law fails pretty much all of these. It has a good faith prerequisite. It only allows you to go public if it does not allow you to go public if there's a fear of retaliation for operating within internal channels, or if there's a concern that there will be destruction of documents and evidence if you disclose the wrongdoing internally. Those aren't grounds to go public. It's almost like you're required under this law to enable obstruction of justice in order to protect your rights. Even within your organization, you can go to your supervisor, but you can't go to the rest of the chain of command. And what if your boss is the one who's engaging in the wrongdoing? You can either go to your supervisor or a designated senior official, which we'll talk about separately. But there's no free flow of information, even within an organization. And this is really significant because 90% of whistleblowing is within the organizations. It's not breaking ranks from the institution. So you've only got two outlets within your workplace, your direct supervisor and a senior designated official. Otherwise, you sacrifice your rights. Well, the law obviously is flunking on multiple grounds for that criteria. The second criteria is to cover a broad scope of subject matters. Basically anything that could betray the public trust. And Canada's law here isn't too bad in a lot of respects. covers all illegality, threats to public health or safety, misspending, mismanagement. But unfortunately, it doesn't cover the most basic protected speech category, abuse of authority. Those things which may not be technically illegal, but are betraying the public trust because of some sort of political favoritism or discrimination. That's the cornerstone of every whistleblower law, except Canada's. It's the only country that doesn't cover that type of misconduct. There's also a very kind of strange loophole in what you can blow the whistle on. Is you can't disclose misconduct outside the subject matter, outside the scope of your agency's jurisdiction. So say you're a government official and you're teaming up with another agency and you find out that they're not doing their share in the investigation, or they're part of the corruption, they're part of the misconduct, or that they're violating the law in how they handle it. You don't have any free speech rights if you blow the whistle on that. You can't defend yourself against any ensuing retaliation. The third criteria is refusal to violate the law, that you have the same rights for refusing to engage in illegality as you do for making noise about it. That's in relatively few countries, but a few, and they're very, very significant. Otherwise, you have to obey orders and just complain about it afterwards. And if it's doing something which is really unacceptable, like some human rights violation or engaging in illegality yourself, it puts you in a pretty bad spot. Canada's law doesn't cover that. The fourth criteria is protection against spillover retaliation. Analogizing to a past U.S. presidential contender's book, Takes a Village to Raise a Child, it takes a village to blow the whistle responsibly and effectively. You can't just protect the final messenger. It takes a whole team to prepare a good whistleblowing disclosure. That means you have to protect all the people who contributed to exposing the truth. So you have to protect those who assisted the whistleblower. You have to protect the ultimate messenger or anyone else who's engaging in the research that exposes, and they're researching something that can't be defended by the institution. And so that'll draw suspicion. You have to disclose those who are about to blow the whistle, because otherwise there can be a preemptive strike against them that before they even have a chance to get the information to the right authorities. You have to protect those who are perceived as blowing the whistle, maybe mistakenly, because that can certainly increase isolation. If you don't protect all those folks, the whistleblower is going to be very lonely. And in our experience, and I've worked with 9,000 whistleblowers since 1979, isolation is fatal. If the whistleblower is alone, no matter how good the law is, it's going to be a disaster. They're going to be destroyed personally, and they won't accomplish much. With solidarity, it's very difficult to stop the truth. You can say one person is a kook or a liar or something, but it's very, very difficult to deny when 20 or 30 people are all testifying about an abuse of power. It becomes almost a foregone conclusion that the whistleblowers are right. You need protection for the whole team, not just the final messenger, or the system's going to break down. Canada doesn't protect anyone except the final messenger, and it's a severe weakness in the law. The sixth is reliable identity protection. Well, the law has kind of a general principle. The chief executives have a duty to protect identities, but there's no infrastructure for it. And this is very, very significant factor for people who are afraid. And it's also very significant that they remain confidential so they can keep having access to evidence and information to contribute to an investigation of corruption or abuse of power, illegality. Once they're identified, the flow of information will completely dry up. That'll be the least of their problems, is ignorance, be fighting for survival. But as long as they're confidential, they can remain effective witnesses. So for both their own protection and for an effective investigation, you have to have it. And there's certain basic principles that are necessary for confidentiality. The first is that you protect not only the identity, but all the identifying information, things that could be traced back to the whistleblower. The second is that you don't disclose any identifying information without advance written consent from the whistleblower. The third is, and that's for discretionary judgments. The third principle is for non-discretionary contexts, such like a court ordering the identity. In many circumstances when you can't remain confidential, people have a right to confront their accusers. For example, if there's a criminal trial, that the whistleblower gets timely advance warning and notice that their identity is going to be exposed. There's nothing worse than going to work thinking you're anonymous, confidential whistleblower and getting swarmed by angry employers. So give you the third degree then. You've got to be able to make your plans if you're going to be exposed. And the fourth principle is that the confidentiality pledge travels with the evidence if the case is referred or delegated to a different agency. Well, this law just doesn't cover any of that. It barely touches on the premise of confidentiality. The seventh best practice is protection against the full scope of harassment. 2/3 of the nation's whistleblower, of the world's whistleblower laws now go beyond workplace harassment, protecting against violence, for example, or civil and criminal liability, which can be a lot scarier than getting fired. This law doesn't protect against any of those things, and it doesn't even cover the full scope of workplace harassment. It doesn't cover retaliatory investigations, for example, which are the knee-jerk first stage of any harassment. And you're defenseless against the witch hunt until they act on the witch hunt. It doesn't cover such things as psychiatric referrals, very common technique, not only in Soviet Union, but in the United States against whistleblowers to try and get them branded as crazy. It doesn't cover passive retaliation, where you simply don't provide training for a whistleblower, or you don't give them promotion. It only covers active kind of direct attacks, not passive aggression against whistleblowers. It just isn't going to, it's not going to be there when the rights are needed against relevant harassment. The eighth best practice category is protection against gag orders. Very frequently, as a condition of being hired at an agency, the whistleblower has to sign a non-disclosure agreement. That's a job prerequisite, and it cancels out all their rights under the statute. Almost all the world's whistleblower laws say that our law trumps any gag orders that are connected with your job, not Canada's. And I mean, to go back for a second in terms of protecting all the people who should be covered, not just the final messenger, it only, the most basic weakness in this law is it only covers government employees. Almost all the world's whistleblower laws cover government or corporate employees, and many of them go beyond that, give rights to corporations or contractors, because it doesn't matter who is supplying the evidence other than for purposes of credibility. We want to protect the free flow of all the information that's necessary to defend the public interest. The ninth category is having essential support services. Unemployed whistleblowers who aren't lawyers, they're in very scary and alien foreign territory for them. They need a navigator. They desperately need to have navigators. And there is a public service commissioner under this law who's got responsibilities to provide advice. But as we said, that public service commissioner in practice has been a consistent barrier to people getting relief or support under the law, or even having an opportunity to fight for their rights. So it hasn't been an effective resource. There needs to be an agency that's independent from acting as the judge or the preliminary judge, who's just a service agency to help people learn about their rights. In fact, the commissioner is absolutely a Trojan horse in this law. The commissioner has a blank check to dismiss any whistleblower case for virtually any grounds. If they don't think it's appropriate, or if the commissioner doesn't think it's in good faith. They have complete immunity for their actions. They're shielded against any liability. They operate 100% secrecy. They don't have to justify their decisions any more than they feel like. The commissioner structure is basically an invitation for the whistleblower law to be a Trojan horse that advertises rights and then routinely denies any access to them. And it's absolutely the primary obstacle of this law. And that leads into the 10th best practice, that you have a genuine day in court to act on your rights, due process. And as we've seen, the commissioner structure blocks that. It vetoes your opportunity for due process. Even if the commissioner thinks that your rights are violated, the commissioner may apply to the tribunal for your case to be heard. After finding a violation, they're not under an obligation to give you an opportunity, you as the whistleblower, an opportunity to act on the violation of your rights. It's simply an unacceptable structure. The tribunal where you would have due process is the Public Servants Disclosure Protection Tribunal. They're so frustrated that a few years ago they invited me up to visit with them to see if there was any way that they could finally start getting some cases. And there really was no way under Canada's current law. They're at the mercy of the commissioner. The 11th best practice criteria is the option for alternative dispute resolution. The commissioner can appoint a conciliator, which would spark mediation. They don't have to, though, and the opportunity to ask the parties if they'd like to have a settlement is really nothing that you even need a law for. The 12th best practice criteria is burdens of proof that are realistic. This is how much evidence it takes to win your case. If you need this much evidence, it may be unrealistic. If you need this much, it is realistic. Canada's law doesn't have the burdens of proof specified. That means that it's vulnerable to arbitrary decisions. And globally, the structure is if you make a prima facie case of retaliation, the burden of proof shifts. There's a reverse burden of proof. It shifts to the employer to demonstrate that their action was innocent, that it was not retaliatory. Well, you folks don't have and that's been refined. The European Union Whistleblower Directive said, if you engage in protected speech and something subsequently happens to you, that's your prima facie case. Then the burden of proof shifts to the employer to prove that the whistleblowing was not linked or connected in any way with the final decision. There was no reprisal contamination. Here, there's no burdens of proof. There's not even a crude reverse burden of proof. It's like, the law isn't really literate in terms of legal standards. Realistic time frame to act on your rights. At least 6 months, 1 to 3 years is the common best practice standard. In Canada, you have 60 days. That may not even be enough time to find a lawyer, let alone prepare a case and file it. Compensation, you need to be made whole. If you do survive this gauntlet and actually win a case someday in Canada, that you won't be any worse off than before your rights were violated. Otherwise, you can lose by winning. The Canadian law only provides, it does provide for reinstatement, but only consequential damages, bills you directly incurred, and a cap of $10,000 for pain and suffering. Well, that's just token relief for someone who may have gone years and years and years, been professionally ruined. Doesn't cover things such as destruction of your professional reputation or credibility. It's not a make-whole remedy. Interim relief, these cases can take 5 years, as you've seen, just to lose. Or if it takes 5 years to win, that may be too late. By then, you've already lost your home, your family is broken up, your professional credibility is irrevocably destroyed. It's essential to have interim relief if the employee makes a prima facie case that shows there was some possible contamination, that we freeze the action until the facts have been settled, have been sorted out. And that will eliminate a lot of unnecessary conflict, because if there's an interim relief, the employer has every incentive to resolve the case on terms the whistleblower can live with, because the employer is losing until the case is over. If there's no interim relief, the employer is winning until the case is over, and they'll drag it out as long as possible. Well, let's go to being able to afford your rights. Attorney fees being available or cost. I might be mistaken on this if there's some general provision in Canada's civil procedure, but the whistleblower law doesn't have any provision for attorney fees. And the commissioner can allocate up to $1,500 to get you legal help while your case is at that office. In other words, you're on your own in terms of being able to pay for your rights. And people who are unemployed, that's a pretty tough challenge. The 17th best practice is a transfer option. It's very difficult to go to work for a boss that you just defeated in a lawsuit. So solid whistleblower laws allow you to get a fresh start, not Canada's. Personal accountability. This doesn't have any proactive procedures. There is a possibility of personal accountability, and there's criminal liability, but there's no proactive procedures for the commissioner to institute proceedings. The tribunal may institute some proceedings for accountability. It's pretty much theoretical until there's a finding that anyone has violated the law, but there's not a credible deterrent in this law. The 19th best practice criteria may be the most significant: credible corrective action. All the studies have shown that the most severe chilling effect is cynicism, not fear of retaliation. It's cynicism, that it won't make a difference to risk the retaliation. And this law doesn't really have anything that could provide confidence in the corrective action. Now, the chief executive officer of an agency does have to make internal reports public if there's a finding of wrongdoing. But the commissioner's office, which does the main investigations under the law, they don't have any responsibilities for transparency. They don't have to investigate a case if they think there's a valid reason not to. Or if they don't like the good faith of the whistleblower who brought it in. Or there's, listen to this excuse: if the subject matter of the disclosure or the investigation relates to a matter that results from a balanced and informed decision-making process on a public policy issue. Well, for goodness sakes. In other words, the commissioner doesn't have to investigate anything. And when he or she does investigate it, the whistleblower is not entitled to participate in the investigation, to comment on the draft report. There's no requirement to share the results with the public. What's the point of taking the risk under this law? The final best practice criteria is review, since no nation can ever get it right the first time. In Canada's law, this is the one best practice criteria that Canada's law on paper complies with, review after 5 years. But in reality, it hasn't been complied with. In fact, the 2017 report, after 10 years after the law went into effect, wasn't even formally transmitted to the rest of the parliament. So it's been completely ignored, and in practice, Canada complies with none of the 20 best practice criteria. folks, that's the assessment that I wanted to share with you. Thank goodness for groups like Whistleblowing Canada, the Center for Free Expression at the university. Those of you who are working in the front lines to try and challenge this global disgrace. The bottom line for a group like where I work, the Government Accountability Project, if we were stationed in Canada, if someone came to us for advice, we would be warning them against using this law. Exercising your rights under this law means a prolonged struggle that where you have no rights within the process, that almost certainly will result in a formal endorsement of whatever retaliation you are seeking. It's better to pursue your dissent outside the scope of the law until Canada gets a whistleblower statute that's legitimate. I think we've got a little time left, David, for questions and answers, and I'm glad to contribute that way.
Sure, Tom. Thank you very much for your presentation, and it's very rich in information, and it's excellent that you've put together these criteria, which are sort of self-evident in terms of evaluating a law, and it's an easy way to seek guidance or at least comparison about various laws. I know, Pam, you wanted to ask a question of Tom, I guess a practical, I mean, here we are presented with a law which is clearly defective, both in writing and in practice, but how do we change that? I know, Pam, you wanted to ask some questions about that.
Yes, thank you. I do, Tom. So I'll start out with the question. It's a two-part question, and then give a little background. So I guess my question is, what can citizens do when, in spite of legally mandated obligations in the law, for governments to take certain actions to improve the current Federal Whistleblower Protection Act, they simply continue to act contrary to the law rather than to improve it? And the second follow-up part is, when politicians act as though laws do not apply to them, what does this mean for the rule of law and democracy in our country? So just a little bit of background for those who may not know what I'm talking about here. So in Canada, successful federal governments have acted in a way that demonstrates a strong political will to maintain a culture of secrecy and all that that implies, in spite of incessant calls from citizens for openness and transparency. For example, our Access to Information Commissioner reported to a House of Commons committee hearing just in February that our access to information system is so broken, it is verging on being unfixable. Others reported that our federal whistleblowing protection law does not work. And it is seen, as Tom has mentioned, by analysts and others who have studied it, as a trap that suppresses and punishes rather than empowers and encourages honest employees to speak up safely. So this intransigence and unrepentance has gone so far as to see successive governments, including this one, seemingly break the Whistleblower Protection Act itself rather than fix it. And I'm just going to mention the three things, or actually there are four things that they do that are actually in violation of the law. The first one, Tom has already mentioned. The act, there was an obligation mandated in the act to do a 5-year review. And these reviews are done to identify needed improvements. This was never respected. A review was done 10 years later in 2017, contrary to the act. Second point, the review was done by a committee of the House of Commons in 2017. Unfortunately, it was not an independent review, contrary to the obligation as mandated by the act. again, a violation. In the 2017 report from the OGO committee, and it was a good report, it was unanimous. Yet not one MP, not one member of parliament from either the government or the opposition stood up in the House to request a motion to concur with the report and the recommended improvements. And so the report was also, this is the fourth one, not tabled in the Senate, again, in apparent violation of the Act. So the government did nothing to pass the recommended improvements in the report, but simply ignored it. Now, there was another recent movement, but as a result of all of the previous, there's a lot of skepticism and very little trust about the sincerity of the government or even the opposition when they recently retabled that very report. They retabled it in February, but again, no one from either government or opposition stood up in the House to ask for a motion to concur. They're simply following the same procedural path that led to the burying of this very good report some 4 years ago. So then back to my question, what can citizens do? And when politicians act as though laws do not apply to them, what does it mean for the rule of law and democracy in our country?
Thank you, Pam. We face the same challenges in the United States. Sometimes we seem to be setting the pace globally for those kinds of challenges. So it's a common problem that we have to try to overcome at Government Accountability Project. And there's basically two strategies that we've used. One is simply organizing the broadest possible bipartisan, trans-ideological coalition of support. For example, the last time that we got improvements in the US whistleblower law in 2012, we organized a petition from 400 NGOs and companies with 80 million members. And so when we would be engaging in advocacy in Congress, we weren't just speaking as the do-gooders. We were speaking on behalf of 80 million voters. And we've worked to get polls checking this. And like, for example, in the United States, last fall, there was a poll by the Marist Corporation that 86% of likely voters want stronger whistleblower rights. And you better believe we're sharing that research, that data research, with every office we speak to. Just in the first month of this year, we got 266 groups on a sign-on petition. And as we continue our advocacy, over time, we keep adding to that. And reminding the politicians, well, we're up to 300 groups now, and these groups that are powerful in your district or state have just joined us. Some of them would like to talk to you about this issue. Can we matchmake? So that's one aspect of it. The second aspect of it is the theme for advocacy in order to recruit that wide coalition. And if the magic word in real estate is location, 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 for whistleblowing, it's consequences, consequences, consequences. We don't, we certainly don't skip that freedom of speech is an important human right and civil liberty. And it's the main reason why I do this work. But that's not the theme of our advocacy. We've got to strengthen human rights. We highlight, spotlight how whistleblowers have made a difference, how when we listen to them, they saved lives. And we're advertising and boasting about their results, their accomplishments all the time. then from the other side, what happens when we don't? What are the tragedies that shouldn't have occurred if we'd only listened? That's the primary theme that we have in recruiting support from other stakeholders and NGOs, is teaching them how the whistleblowers can make a difference for your mission. It's almost like, the balance of power. There's the public interest groups and the citizen organization. They can maybe affect 10% of what the people who have the power really want to do with it. They can roll it back 10% because of their pressure. Well, thanks to the whistleblowers, they may be able to roll it back 20 or 30% of the abuse of power, because the whistleblowers supply them the informational, the truth, the informational evidence. That's the weapons that are the most powerful there is. And so it's a twofold strategy. Really highlight the consequences to stakeholders and to politicians, and then to be using that as a base for a political base that, in the States, it's so broad, from the most conservative to the most liberal groups. They all need to have the truth, whatever their conflicting mission is. They need the truth. And so they unite behind that principle. The second question that you had, Pam, was, well, when the government's violating the law, what does that mean? Well, it basically means that the rule of law, the hidden objective and the realistic impact of the rule of law is to sustain abuses of authority by those who have the power, rather than to provide justice, which is the stated objective of the rule of law. And I think it's very ironic and telling that Canada's whistleblower law doesn't have a protected speech category for abuse of authority.
Thanks, Tom, for that. Just a couple of comments. One, in terms of consequences, it's interesting that the federal legislation has a pretty positive preamble, which talks about the fact that encouraging employee free speech is actually central to the rule of law and to the functioning of a constitutional democracy. The problem is that the words that follow, the ones that actually mean something, are not all that effective and not applied that well. But at least it emphasizes the consequences. It's not only practical in terms of health and safety, but also just the functioning of government, which is an important point. And the second thing that you mentioned, which is consistent with my experience, is that the political spectrum has an interest in strong whistleblowing laws, from left to right, from conservative to liberal, and everybody in between. And I've seen, sometimes it's used politically, but practically speaking, everybody has an interest in that. So it's really an unusual scenario where you could build a broad coalition. It's just that the institutions that are going to be subject to the scrutiny are resistant to that kind of change, and that includes the federal government. Our session is supposed to be over now. We probably have a few extra minutes, and Tom, I'm respectful of your time as well, so please let us know.
I'm free until a quarter after, and since we started about 15 minutes late, I'm glad to stay on if there's any further questions.
Sure. So there's a couple now in the queue. One, somebody put a question in the chat, which you may or may not be able to answer as it relates to Canada. But question from Jesse is, are courts part of the problem in Canada by insisting on disclosing the identity of whistleblowers as a default posture? And if so, who should address this issue to promote change? Any thoughts on that, Tom?
Sure. It's almost unavoidable that your identity will be exposed at some point if the disclosure is sufficiently effective. And so I always warn people who come into us that we can protect your identity for as long as possible, but sooner or later you're going to have to come out of the closet if you're really effective, because the person who deserves to go to jail does have a constitutional right to challenge your evidence and cross-examine you, and that works in all directions. So I warn people it's not absolute, but usually the problem is not the courts. doing that sort of constitutional or fundamental right to confront your accuser. Usually it's sloppiness or betrayal by the agency that the whistleblower entrusts to act on their concerns. And that's very, very significant problem. It has an extreme chilling effect. If whistleblowers don't trust the investigative agency, like a particular inspector general or whatever, to keep their identity secret, they won't go there. So it's essential for legitimacy and to thaw the chilling effect. And like I said, there's really 4 parts to this. Protect identifying information. You get advanced permission for any discretionary releases. You give advance warning for any non-discretionary release, and that the commitment travels with the evidence.
Thanks for that, Tom. That's very helpful, and I'm glad you emphasized to the disincentive to whistleblowers that occurs when there's no confidence around some of these issues, including the protection of their identity. We're dealing with a process that's really personal in some cases and depends on the circumstances. And at the end of the day, we want to encourage people to speak out, and unfortunately, it doesn't always work that way. There's somebody who's raised their hand. Rhonda, do you have a question here?
Hey, yes, thanks. Yeah, so Tom, I'm wondering, in terms of Canada, aside from the federal government, how much you would know about the rest of Canada? For example, the private sector. If you mentioned about being about people being isolated, and so the need for people to report in groups, and often that's not possible when you're reporting to a company, and say, for example, you call a whistleblower hotline, and then you face retaliation. And I'm just wondering if you have any kind of experience or any comment about what happens when you call a whistleblower hotline and you're faced with that same kind of retaliation. Because when you went through those 20 criteria, I don't actually find that it's any different when you're in the private sector. And it's the same situation really, where you have no rights, and you end up, I guess you end up essentially in the same place as the way you describe the federal whistleblowers. And I'm wondering if you think Canada is any different than anywhere else in the world.
Oh, to start with your last point, I don't think that Canada is better or worse than other countries in terms of the drive to retaliate, the rates of retaliation. Right. I found this to be pretty much a universal trait, that it's almost like the institutional equivalent of an animal instinct. When an animal is threatened, it wants to destroy the threat, and whistleblowers are threatening those who abuse the powers to destroy them. So it's dangerous. It's dangerous everywhere. The lack of coverage for the private sector is, along with the lack of access to due process, the two most significant deficiencies of the statute. And it can be very treacherous to go to an anonymous hotline. There's no particular standards or requirements for them, and they vary dramatically. Some of them are very secure, and they're not only secure, but they will have codes so that there can be follow-up dialogue without having any personal interaction or exposure of identity. And there's really an impressive cottage industry that's sprung up around anonymous hotlines. But that depends on the good faith of the of the company that's using them or the agency that's using them. And a lot of them are, they are traps. And what I would suggest is going to our website, the Government Accountability Project, where I work. It's www.whistleblower.org, whistleblower.org. And there's a resources page there. And we put together a book with a couple of other NGOs that support whistleblowers called Choosing Between Conscience and Career: How to Expose Wrongdoing Without Exposing Your Identity. And really, this is kind of a guide for how to securely communicate, even with an untrustworthy hotline, how to camouflage your own identity, such as sending information from a neutral source, such as a burner phone or a public library, using secure drop. There's only using telephone lines on particularly secure channels. We did a lot of research for that, and you should assume the worst and do your homework. And if you do, you can probably get the evidence into the right hands. Another thing that I like to advise, particularly with a hotline, is go to multiple hotlines. There's usually more than one that'll be relevant. And it's what we do with investigations too. We don't just go to one outlet to investigate. We try to have multiple investigations so that any one institution doesn't have as much of an option to cover up because the other ones might catch it, and it's unwieldy to collude between too many different sources. So I work with whistleblowers to go to as many hotlines as possible. There'll be at least a government one, at least one corporate one. A lot of times there's like a law enforcement hotline that's relevant too, and we can usually find 3 or 4 that they can disclose the same evidence to. Just being very, very careful how they do it.
Thanks for that, Tom. I'm mindful of your time again. Just maybe we can squeeze in another quick question, and you can take the time that you think you need or you have. But somebody's asking about risk assessment, which is often in the legislative process is something that is done to look at a law, especially lately, I guess. And do you have any sense of criteria that are used typically as a basis for this kind of risk assessment? And they tend to focus on victims of, offenders or victims, etc. Any ideas there that might be helpful just in assessing it?
I wasn't really sure what was meant by that question, risk assessment. Most of the protected speech categories are pretty absolute. There could be risk assessment for something like substantial danger to public health or safety. But even then, it's not a balancing. Like a lot of laws that are somewhat unpopular, they say, well, you can't do this unless the cost would be too great to defer. Unless it's not, we're going to protect the environment unless it's not worth it. The whistleblower laws generally don't have that balancing test. They're absolute categories of protected speech. Now, there are going to be judgment calls over whether, for example, the public health or safety threat is serious. So there's that kind of judgment call, but not like cost benefit weighing of the public interest versus the price for respecting the public interest. I haven't seen a whistleblower law that requires that kind of a trade-off.
Okay. Thanks so much for your answer, and thanks generally, Tom, for taking the time here. I know you're a busy person, and we certainly appreciate your review and your insight. And
I'm glad we connected. I really wanted to talk to you folks this morning, and I wasn't sure it was going to happen.
I'm sure we'll hear from you again. But once again, our appreciation greatly for spending the time with us today. And so we're at the end of our session. I did want to remind everybody that Whistleblowing Canada is having another webinar on May 12th, and that one will feature the speaker Ed Schmidt, and Edgar is speaking on whistleblowing necessary for democratic governance and the rule of law. It's taking place at noon Eastern Standard Time. You can go to the Whistleblowing Canada website to find out about the webinar and to register. Registration is free, although we encourage donations. Anything else from you, Pam, in terms of the process and where we're at and what we're doing?
No, not at all. Thank you so much, Tom. We do appreciate your efforts, not only to help us here in Canada, but you're a very active global citizen. And we do appreciate you very much. And thank you, everybody, for attending. And we do hope that you'll be able to support some of our efforts, and you'll be hearing from us. Thanks again, and goodbye for now. See you next
Thanks
time.
for having me, folks.
Not at
Thanks,
all.
Tom. Thanks, everybody.
Bye now.